Welcome to The Explainer. Ever stop and wonder how a simple idea, maybe something you scribbled on a napkin, actually becomes a real company? A legal entity that can, own things and sign contracts? Well, today, we're pulling back the curtain on that whole process of incorporation. We're going to break down the essential steps that turn that spark of inspiration into a corporate reality. So, how does that big leap actually happen? How do you go from a concept to a legal entity that can open a bank account and hire people? Well, it's not magic, that's for sure. It's a very deliberate legal process. And it all kicks off with one specific person, or maybe a few people, who gets the whole ball rolling. Okay, let's get into it. Here's what we're covering today. First up, we'll talk about the architect of the company, who the law calls the promoter. Then we'll look at the different kinds of company structures you can choose from, a really big decision. After that, we'll get into the company's constitution, its core documents, and then the really crucial rules of the road for how it deals with the outside world. And finally, we'll see how companies can change and adapt over time. All right, first things first, let's meet the architect of this new venture. This is the person doing all the legwork, all the foundational stuff to get a company off the ground. In the language of the Companies Act 2013, this key player has an official title, the promoter.
So what actually makes someone a promoter? The legal definition is pretty wide, actually. It could be someone who's officially named as a promoter in the company's paperwork, but it could also be someone who's really pulling the strings, someone with direct control over the company's business. And get this, it can even be someone who the board of directors is used to listening to for advice. The bottom line is, if you're taking the necessary steps to form the company and get it launched, chances are, in the eyes of the law, you're a promoter.
So, with the big idea in place, the promoter hits their first major crossroads. What kind of company are we actually building here? And this choice is huge. It's foundational. It's going to affect everything from how many owners you can have, to your legal duties, and even what you have to put at the end of your company's name. Let's break down the main options under the Companies Act 2013. You've got your public company, which needs at least 7 members and has no maximum limit. Think big. Its name has to end with the word limited. Then there's the private company, which needs at least 2 members, but it's capped at 200. Its name will always end with private limited. And then we have the really interesting one, the OPC, or one-person company, which, yeah, you guessed it, can be formed by just one single person.
Now, this one-person company, the OPC, was a total game changer when it came out in the 2013 Act. It was specifically designed to give solo entrepreneurs a huge leg up by letting a single individual form a company with that massive benefit of limited liability. Now, there are a few rules. The founder has to be a natural person and an Indian citizen. And, this is really important, they have to name a nominee who can take over if they pass away or can't run the business anymore.
And this example brings that nominee rule to life perfectly. So Rajesh has his OPC and his wife is the nominee. But when she falls ill, he needs to pick someone else. His adult friend, Ramnivas? Perfect. Totally valid choice. But his 17-year-old son? Nope, can't do it. The law is crystal clear. A nominee can't be a minor. It's a straightforward rule that just highlights the fact that the nominee has to be a legally competent adult ready to step in if needed.
Okay, now let's get into the company's legal DNA. Every single company is built on 2 core documents, the Memorandum of Association and the Articles of Association. And you should really think of these as more than just paperwork. They're the company's constitution. They define what it can do and the rules for how it does it. Let's think about it like building a house. The Memorandum of Association, or MOA, that's your blueprint. It sets the property lines, it defines the company's name, where its main office is, and most importantly, its objects. Basically, what the company is legally allowed to do. This is the supreme document, the absolute boundary. The Articles of Association, or AOA, well, those are the internal house rules. They say how the company is going to be managed day to day. Things like appointing directors, holding meetings, and how voting works. The AOA is always secondary. It has to operate inside the boundaries set by the MOA. All right, so the company is officially formed, its constitution is written, now what? How does it actually interact with the rest of the world? Well, there are a few incredibly powerful legal doctrines that everyone, both inside and outside the company, absolutely has to understand. These aren't just suggestions, they are fundamental to how company law works.
The first, and maybe the most critical rule, is the doctrine of ultra vires. It's a Latin phrase that literally means beyond the powers. What it means is that any action a company takes that is outside the scope of its objects, the stuff listed in its MOA, is legally null and void. It's not just that it's unauthorized. From a legal perspective, it's as if it never even happened.
To really get this, we have to talk about the classic case, Ashbury Railway Carriage and Iron Company versus Rich. This slide shows you the exact words from their MOA. Their purpose was spelled out very clearly: to make and sell railway equipment and to work as mechanical engineers. That's it.
So here's what went down. The company made a deal to finance the construction of a new railway line over in Belgium. But then they tried to back out of the deal and got sued. The court's decision was a landmark. They said, look, financing a railway is not in your MOA, therefore the contract was ultra-virus and completely void. And here's the real kicker. The court said that even if every single shareholder had voted to approve the contract, it would still be invalid. Why? Because you can't approve something the company legally had no power to do in the first place.
Now that leads us right into the next big principle, the doctrine of constructive notice. Since the MOA and AOA are public documents filed with the government, the law just assumes that anybody dealing with that company has read them and gets what they mean. You can't just say, oh, I didn't know. That's not a defense. The law's perspective is basically, you should have known.
And this rule can be pretty harsh in the real world. Imagine a company's articles say any large check needs 2 directors to sign it. A supplier accepts a check for a big amount that's only signed by 1 director. When that check bounces, the supplier tries to sue, but the court is going to side with the company. They'll say the supplier had constructive notice of that 2-signature rule because the articles are public. It's a tough lesson, but the law is blunt. You should have checked the rules first.
Right about now, you're probably thinking, hang on a second. Sure, an outsider can read the public documents, but how on earth are they supposed to know if the company actually followed its own internal procedures? How could they possibly know if a shareholder meeting that was supposed to happen actually happened? It seems a bit unfair, right? Well, this is where the law steps in with a really important counterbalance.
And here is that solution, the doctrine of indoor management. You'll also hear it called Turquoine's rule. This is the critical exception to that harsh rule we just talked about. It's designed to protect outsiders who are acting in good faith. It says that while, yes, you're expected to know the public rules, you are absolutely entitled to assume that the company has handled its own internal business correctly. This whole idea comes from the case of Royal British Bank versus Turquoine. Here's what happened. The company's articles said its directors could borrow money, but only after getting a resolution passed by the shareholders. Well, the directors went ahead and borrowed money from the bank without ever getting that resolution. Later, the company refused to pay up, but the court sided with the bank. The bank knew from the public documents that the directors could borrow money. The court said the bank was perfectly entitled to assume that the necessary internal step, getting that shareholder vote, had been taken care of behind closed doors.
So, we have a company with its constitution and a clear set of rules for how it deals with the world. But is all of that set in stone forever? Of course not. Businesses have to change, they have to evolve, and the law provides a clear path for a company to alter its own core documents.
A company absolutely can change its Memorandum of Association. Probably the most common reason for this is to change its objects to get into a new line of business. Let's say a company called Vivek Industries was originally set up to do real estate, but now they see a massive opportunity in food processing. They can legally make that pivot, but they have to alter their MOA's objects clause. To do that, they have to pass a special resolution, which usually means getting a 75% majority of the members to vote yes. It ensures a big change like that has very strong support.
So, we've walked through the whole process of how the law literally creates a company, a legal person with its own rights and its own liabilities, all governed by these foundational documents. But that leaves us with one last and maybe most important question. This whole legal framework builds the body of the company, but who is responsible for its soul, for its moral compass? The rules can define what a company can do, but what determines what it should do? That's a challenge that goes way beyond any rule book. Thanks for joining us on The Explainer.